New York requires both parents to support their child until the child's emancipation. Emancipation is defined under the law until age 21, but often parties can agree to expand the definition. We are often asked by clients whether there is an exception to provide for support after emancipation if the child has special needs. There is such an exception if the child is considered an adult dependent, if the child has a developmental disability as defined under New York's mental hygiene law, continues to reside with the parent seeking support, and is dependent for support from that parent. There are two components to child support. The first is what we call basic child support, and the second is the payment of add-on expenses. Basic child support is a fixed amount of money that the non-custodial parent will pay to the other parent each month. The person with whom the child primarily resides is the parent that is entitled to receive child support. Specifically, it depends on the number of overnights the child spends with each parent. For example, if the child spends every day after school with his or her mom, but then at 6 p.m. returns to the father's home for the overnight and only spends 12 days with the mother overnight, then the father will be considered the custodial parent for child support purposes, and the mom would be responsible for paying child support. If, for example, the parents have an exactly equal number of overnights in a month, the parent who earns more will be the parent responsible for paying child support to the other parent. New York State's Child Support Standards Act, also referred to as the CSSA, is the formula that we use in calculating basic child support. The first thing the court will do is take the combined parental income from the last filed tax returns of the parties and determine a percentage that should be applied to that income for the support of the child. For example, for one child, the percentage is 17%, and for two children, it's 25%, and so on. The court then applies the appropriate percentage up to a parental income cap. The income cap under the statute is $163,000 as of 2023. When the party's income exceeds the statutory income cap, a court can determine whether additional child support is warranted under those circumstances. In counties making up New York City and Westchester, the court will often apply the child support calculation to an income above the cap. Often we'll see something from $350,000 to $600,000 being used as the income in determining child support. There is another component to child support under New York law. The second component is the payment of add-on expenses for the child. Add-on expenses are defined by statute in New York quite narrowly as the childcare costs necessary for the custodial parent to work, the child's health insurance costs and other unreimbursed medical expenses, and in certain circumstances, educational costs. Parties may decide by agreement to limit or expand their obligation to add-on expenses, such as summer camp costs, tutoring expenses, SAT prep courses, the child's cell phone, and various other types of expenses that are commonly paid for children in New York. Most divorce cases do not go to trial, but parties settle their support arrangements and custody arrangements by agreement. In those circumstances, as long as the parties acknowledge that they were made aware of the Child Support Standards Act and the formula that is provided for child support, they can make their own arrangements and agreements on how support should be structured between them for their child.